Welcome to the Housing Law Help Series. I'm an attorney at Klok Law, and today I'm going to share with you some information regarding the eviction process in South Carolina. South Carolina has its own Residential Landlord and Tenant Act that sets out the rights and obligations of landlords and tenants, including the procedure for eviction. One of the most common reasons a landlord evicts tenants is because they have not paid their rent. Before a landlord may evict a tenant, they must first give the tenant a 5-day notice to pay rent, or the landlord will begin eviction proceedings. However, if the landlord included a statement in the lease that the tenant has 5 days to pay rent after it is due, or the landlord will begin the eviction proceedings, the landlord does not have to provide the written 5-day notice. In particular, the language that must be included is, if you do not pay your rent on time, this is your notice. If you do not pay your rent within 5 days of the due date, the landlord can start to have you evicted. You will get no other notice as long as you live in this rental unit. If the tenant does not pay the rent by the end of the 5 days, the landlord may terminate the lease and sue for possession. In addition to suing for possession, the landlord may recover actual damages and obtain injunctive relief, judgments, or evictions in magistrates or circuit court without posting bond for any non-compliance by the tenant with the rental agreement. It is important that both tenants and landlords understand the eviction process in South Carolina. Thanks for listening.